Hi everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here with our latest R. Kelly update. And so I don't think I put it in a video, but I may have posted it in my community section, where R. Kelly's attorneys are appealing to the United States Court of Appeals for the Second Circuit to overturn the 3 denials by Judge Ann Dunley in hopes of getting him released pre-trial. And so they finally put together their motion that they submitted to the courts, and they did that yesterday. And so it's 208 pages, y'all, and I am not about to read these 208 pages. If you're not familiar with my channel, this is your first time coming on. I do read the indictments and the charges against R. Kelly, any records that come out regarding his case. I do videos and read those documents, but those documents are usually anywhere from 10 to 20 pages. In this instance, this document is 208 pages. And so when I first downloaded it, I was like, what the hell? But I did read through the document. I took about 3 hours to read through it. And basically, it includes every document that I have read to you guys in previous videos. And so if you are new to the channel or you're looking for information regarding some of the content that I'm going to share today, just go back. I have a playlist. It's called R. Kelly playlist, I think. R. Kelly series is what it's called. And so you can go back, find that playlist, and just go through it. There is probably about 50 videos under that playlist covering everything from when he was first, when the Doculies came out, the Surviving R. Kelly thing that got this whole ball rolling. I have videos, starting back from January 2019 all the way up to now. And so you can go back and review some of that content. So let's go ahead and get started with this appeal. Like I said, the document is 208 pages, but actually what I'm going to read to you guys is and I may not even read it verbatim. It just depends on how it goes. And so the attorney that's representing R. Kelly in this appeal, his name is Thomas A. Farinella. And so he's petitioning. He says, I am an attorney with the law office of Thomas A. Farinella, PC. I represent defendant, appellant Robert S. Kelly, and I offer this declaration in support of his motion for an order reversing an order of pretrial detention entered by District Court Honorable Ann M. Donnelly on May 15, 2020. And then it goes on, say, I respectfully submit with this declaration the memorandum of law in support of Robert S. Kelly's motion for release for pretrial detention, dated June 29, 2020. The memorandum of law in support is attached and is Exhibit A. And Exhibit A is what we're really going to talk about in this video. And so he basically goes through a history of, he says, Mr. Kelly has been charged in districts with violating, you guys know by now, United States Code 18, and then 22, 51, 24, 21, 22, and 23. And, he talks about the Northern District of Illinois and what charges he's facing there. On June 16th, Judge Harry Lionweber entered a permanent order of detention in the Northern District of Illinois, case number 19 CR 00567. On August 2nd, 2019, there was a bail hearing held in the district court before Magistrate Tissie. The transcript of the bail hearing is annexed hereto as Exhibit B. And so when he's talking about these exhibits, that is what's making this document 208 pages. So he's basically putting transcripts from the hearings, and you guys know that federal hearings are closed to the public. They don't have recording and that type of thing. And so basically when we're talking about those hearings and giving you guys the outcome of what happened when he's had hearings, we're just basically giving you a brief outline of what has appeared in the media. Well, in this document is actually the transcript from those hearings. And so there are some interesting things in these transcripts that I'm going to share with you guys a little bit later. And so he says on August 2nd, Judge Stephen Tissie in this case entered the permanent order of detention. The order is annexed as Exhibit C. On October 2nd, 2019, after briefing on the issue and holding oral argument, the district court affirmed the order of detention. And annexed hereto is the briefing on issue of bail before Judge Donnelly as Exhibit D, and the transcript of the bail hearing, Exhibit E. On April 7, 2020, the court denied the defendant's March 26, 2020 emergency bail motion. The decision and order is annexed Exhibit F. On April 21st, 2020, the court denied the defendant's renewed emergency motions for release. That's Exhibit G. On May 15, 2020, the court denied Mr. Kelly's additional request for release. Docket number 68, the order is annexed hereto as Exhibit H. On April 7th, 2020, the court's denial of the defendant's March 26, 2020 emergency bail motion, finding inter alia that the defendant had not demonstrated that he is within the group of people the CDC has categorized as most at risk for contracting COVID-19 because the defendant is 53 years old, 12 years younger than the cohort or older adults defined by the CDC as at risk for severe illness from COVID-19, and 2, continues to pose a risk of flight and a danger to the community, particularly to prospective witnesses. See Exhibit E. The court's medical conclusions are poor at best, and the CDC claims are incorrect. The claim, because he is 53, not 75, he's not at a high risk for COVID. Clearly, risk increases with age, but there is not a rule that only people 75 and older are at risk. They are just at the highest risk. However, 50 to 75 is also an at-risk group. Per the CDC, as you get older, your risk of being hospitalized for COVID-19 increases. Everyone, especially older adults and others at risk of severe illness, should take steps to protect themselves from getting COVID-19. And once again, if you are new to my channel and new to hearing about all this stuff, R. Kelly's lawyers have filed several motions to have him released based on the coronavirus spreading through the prison system. And so the judge in the case, Anne Dunley, has repeatedly denied, saying that R. Kelly really isn't at risk. He's not in a high-risk group, and that because he is a danger to the community and a flight risk, that he should not be eligible to receive bail or bond to await his trial. And so they're outlining some of the arguments that they made, which pertain to the CDC and rulings that they made, and then comparing cases where people have been released due to COVID. So he goes on to say, moreover, it is well established in the supporting memorandum that he is not a danger to the community. Finally, the court did not find the protective measures put in place by the Bureau of Prisons sufficiently interfered with the defendant's ability to prepare for the defense with counsel to warrant his release. And so the Bureau of Prisons, in trying to control the spread of the coronavirus, I believe limited the number of phone calls that inmates could have. They separated inmates, like some people are in individual cells now. And then they limit the number of times that and I couldn't figure out because it seems to change a lot depending on who's telling the story. So I'm not sure if the inmates cannot have visits from their attorneys or the amount of time that they can visit with their attorneys is heavily restricted. And so they're saying that they can't properly prepare for his case due to these restrictions put in place by the Bureau of Prisons. So the defendant is on trial for various charges that span 25 years and needs time to prepare with counsel in person. Presently, none of Mr. Kelly's attorneys are even allowed to visit with him at the MCC Chicago. No one is allowed in. There are no means by which to have lengthy conversations as they are limited to 15 minutes, occasionally 30 minutes. There are no means by which to review evidence with Mr. Kelly, show him documents, review photographs, or discuss strategy. If the present restrictions were lifted, a problem presents. Okay, I know I'm not losing my mind. If the present restrictions are lifted, a problem presents because counsel cannot, Lord Jesus, let me start this over. If the present restrictions are lifted, a problem presents because counsel should not have to go inside of the penal institution at the expense of placing their own health at risk. The health dangers posed by the virus are cyclical. Lawyers visiting clients in jail pose a risk to their clients. Their clients pose a risk to them, and they in turn pose risk to their other clients, colleagues, and family members. Although the courts are going to operate on a limited basis when it comes to trial, lawyers cannot. The court's April 7, 2020 findings are not justified. The court found that the defendant continued to pose a risk of flight because, among other things, he is now facing serious charges in multiple federal and state jurisdictions, and that the risk that the defendant would try to obstruct justice or intimidate prospective witnesses has not dissipated. So he therefore poses a risk to the public. The court further explained that the conditions suggested by the defendant to mitigate his risk of flight and obstruction are inadequate because they can be easily circumvented by the defendant, and they cannot ensure that a defendant with a history, incentive, and opportunity to interfere with potential witnesses will not do so. On May 15, 2020, the court denied Mr. Kelly's additional request for release, Exhibit F. The district court held the defendant, quote, bears a limited burden of production by coming forward with evidence that he does not pose a danger to the community or risk of flight, end quote. And then picks up another quote, as relevant here, temporary release of a defendant is governed by USC 183142, which permits a court to order temporary release for a, quote, compelling reason, end quote. In this case, the defendant must rebut the statutory presumption of pretrial detention under Section 3142E3 or show that a, quote, compelling reason, end quote, calls for the release under Section 3142I. The defendant has done neither. Excuse me. Says that the district court stated that, quote, in an effort to rebut the presumption of detention, the defendant cites his history of return to court in the 2008 case. The significance of that record is substantially undermined by the grand jury's probable cause finding in the Illinois federal case. And I'm not going to read all of this. If you want to know what all of this is about, go back to my last video where I say something like three times a charm or strike three or something like that. But I actually go over the response from the judge, and he's basically summarizing here what her response was and why she denied him for the third time. It says, a finding of probable cause for an obstruction charge does not lead to the logical conclusion that the alleged past crime is evidence of potential obstruction in the case at bar. And so that's something that we've continued to talk about. It's like they keep saying, oh, he obstructed justice. They're putting information out as though it is fact, but they haven't submitted any discovery to the attorneys to support them saying that we know for a fact that he obstructed these people, that he intimidated witnesses. They just keep saying that based on the past trial. And another thing that we talked about in the previous video is if he obstructed justice in the 2008 case, it went to trial 2008. He was actually charged, I believe, in like 2001 or 2002. So if he obstructed justice during those 6 years he was awaiting trial, and then they found out after the trial that he had obstructed justice, why weren't there charges brought against him for obstructing justice back in 2008? Why is it now 12 years later and they're saying, oh, now we have all this evidence that he obstructed justice, but they haven't turned that evidence over to his attorneys? So it says the district court addressed Mr. Kelly's request for temporary release under 3142I, holding, quote, as he did in a previous application, the defendant cites the global coronavirus pandemic as a compelling reason justifying his release. In my prior rulings, I have found that the defendant has not presented compelling reasons for his release under section 3142, and that is a quote from Anne Donnelly. And then he goes on and he's basically citing what she said. And like I said, you can go back and watch that video where I read her response. It says, Mr. Kelly is pre-diabetic. His diagnosis, as the court noted, requires diet, exercise, and weight loss to be managed. The defendant is on total lockdown and cannot exercise or lose weight. This is exacerbating his pre-diabetes and puts him at risk for developing it. As far as the court's review of the defendant's medical records and conclusion he is not, quote, uniquely at risk, is contradicted by the CDC. Per the CDC, quote, because COVID-19 is a new disease, more work is needed to better understand the risk factors for severe illness or complications. Potential risk factors that have been identified to date include, and then this is also in that video where they talk about his age, his race and ethnicity, medical conditions, and poverty and crowding, both of which exist in prison conditions. Although the CDC guidelines are important to follow, this is completely unknown virus. Many people have developed severe complications such as fibrosis of the lungs, long-term permanent pulmonary problems, and there are those that have died from the virus even though they were not, quote, categorized as most at high risk contracting it, end quote. The court did not address the issues raised by defense counsel regarding Mr. Kelly's right to prepare for trial and the fact that he has literacy issues, making it impossible to prepare for trial without being able to meet with him in person. At present, counsel cannot meet with Mr. Kelly to prepare him for the September 2020 trial date in the Eastern District of New York. Wherefore, for the reasons stated in the attached memorandum of law, this court should enter an order reversing the district court's order of detention and directing that Mr. Kelly be released from custody, subject to appropriate conditions of release and any other conditions supported by the evidence and needed to reasonably assure community safety and risk of flight so Mr. Kelly can prepare for trial. I declare under penalty of perjury that the foregoing is true and correct to my best knowledge. And it was signed in New York on June 30th, 2020 by Thomas A. Farinella. And then it has a certificate of service showing that he did submit this to the circuit court. Then Exhibit A, which is his argument. And so in his exhibit, he puts appeal from a detention order of the United States District Court for the Eastern District of New York. And then he has a table of contents, and it includes the introduction, facts, argument, burdens and standard of review. Mr. Kelly met his burden of establishing that he does not pose a danger to the community or a risk of flight. C, the government did not meet its burden of persuasion by clear and convincing evidence that Mr. Kelly poses an irremediable danger to the community. D, the government did not meet the burden by a preponderance of the evidence that Mr. Kelly poses a risk of flight. And E, the continued and unnecessary incarceration of Mr. Kelly also runs afoul of the Eighth Amendment. And F, Mr. Kelly has a fundamental right to proceed to trial expeditiously and a fundamental right to prepare for that trial. And then his conclusion. So we go down, and then he has table of authorities, and these are cases that they are citing as, precedents for why they feel that he should be released. And there are a whole bunch of them. And so, yeah, that's 1, 2, 3, 4. He has 3.5 pages of cases, statutes, and other citings that they are going to include in their argument. United States Court of Appeals for the Second Circuit, number 201720, United States of America, against Robert S. Kelly, blah, blah, blah. And so his introduction says, courts should always, quote, bear in mind that it is only a limited group of offenders who should be denied bail pending trial. United States versus Shakur, 817. And then if you're not familiar, when they cite a case, they give you all the codes and all of the name of the case, the court ID, the case ID. It gives you all of that. And so I'm not going to read all those numbers to you guys because it really serves no purpose. It says, after all, denial of bail under the Bail Reform Act, herein after the act, was not intended to apply to all defendants charged with serious crimes, but only to a, quote, small but identifiable group of particularly dangerous defendants as to whom neither the imposition or stringent release conditions nor the prospect of revocation of release can reasonably assure the safety of the community or of other persons. At Senate report at 3189, emphasis added. Thus, as the Supreme Court has cautioned, quote, in our society, liberty is the norm, and detention prior to trial or without trial is a carefully limited exception, quote, United States versus Salerno. Here, defendant Robert S. Kelly, who will be referred to as Mr. Kelly, moved for pretrial release in light of the coronavirus pandemic and in order to be able to prepare for trial. Docket number 68. The circumstances that exist as a result of COVID-19 pandemic will continue to exist into the foreseeable future and have made it impossible for Mr. Kelly to prepare for his September 2020 trial if bail is not granted. Now, granted, here we are at July 2nd, so his case is supposed to start in like 2.5 months. And so he hasn't been able to meet with his attorneys or go over discovery or any of that. So we know that that trial probably is not going to start in September, and that the Illinois trial is not going to start in October, and the Cook County case ain't starting in September either. So it says, it is undisputed that Mr. Kelly cannot read or write. Therefore, unlike most defendants, he cannot spend hours reading and reviewing the documents that are relevant to his case. He cannot make notes about those documents. He cannot meaningfully communicate in writing with his lawyers, and he cannot meet face-to-face with his lawyers. He has essentially been cut out of the discovery and trial preparation process. Moreover, essentially been cut out of the discovery and trial preparation process. Moreover, because of the pandemic and the conditions imposed by the MCC Chicago, where he is being detained, because of it, his overall communications with counsel are subject to crucial limitations, a sporadic once-a-week short phone call of a FaceTime exchange. This is particularly troublesome as the means of those limited communications do not even possess the safeguards of confidentiality that are necessary to engage in meaningful attorney-client conversation. Moreover, there is no denying that this is an extraordinary time and that the issues that ordinarily affect bail determinations have to be viewed differently and more liberally. Furthermore, the allegations in the indictment in this case span 3 decades. The indictment alleges in sum that Mr. Kelly's care as nationally recognized singer and performer constitutes a RICO racketeering enterprise. Mr. Kelly has lived that career and is in the best position to assist counsel in the review of the discovery. While a defendant is often the best historian in any case, Mr. Kelly's contribution is even more crucial here because the trial court has allowed the government to conceal the identities of some of the alleged victims who would be key trial witnesses. The district court erroneously concluded that Mr. Kelly poses a significant danger to the community that no combination of bail conditions can adequately address, that he is likely to flee, and that the judicial system's oversight capabilities have been curtailed because of the pandemic. However, as the records support, even applying the most stringent standard of review, release should be granted. United States versus Bastani. We review a district court's order of detention for clear error and will reverse only where on the entire evidence we are left with the definite and firm conviction that a mistake has been committed. End quote. Based upon the record before the district court, there is no doubt that a mistake has been made, and it is definite and clear that Mr. Kelly is neither a flight risk nor does he present a danger to the community. As to the nature and seriousness of the quote danger, end quote, purportedly posed by his release, the concern expressed by the district court and the government is that Mr. Kelly may attempt to obstruct justice because he has been charged with obstructing justice in another case. It is certainly not that he is a danger to commit any type of sexual misconduct. Putting aside for the moment the fact that he is presumed innocent, the law does not concern itself with allegations of former conduct, but rather speaks to a real and present danger. Here the danger is merely speculative and without record support. The expressed concern also ignores reality, or as they say, the proof is in the pudding. One of the government's alleged victim Jane Doe's, apparently at the same time she was cooperating with the government, was still living with Mr. Kelly. After Mr. Kelly's arrest and incarceration, the government did not, as would be customary, even seek to bar him from contacting any possible witnesses, but rather allowed Mr. Kelly to have an extraordinary level of contact with that witness. They were afforded pre-pandemic personal one-on-one visits at the MCC Chicago. Yet, through months of contact, there was not a single allegation of any kind of nefarious behavior on Mr. Kelly's part with respect to this Jane Doe, including any allegation that Mr. Kelly ever tried to influence her, pressure her, or to direct her to do so with respect to any other potential witness. And for those of you who are new to the channel, this Jane Doe is Jane Doe number 5 in the Eastern District of New York indictment, and her name is Azriel Clary. So given the district court clearly erred in finding that Mr. Kelly is irremediably dangerous, that no bail conditions can reasonably assure community safety, and that federal pretrial services are incapable of monitoring him, the question becomes what conditions are in fact appropriate. Certainly, conditions can be constructed that would alleviate any legitimate concerns. Location monitoring can be employed. The use of electronics by Mr. Kelly can be restricted or completely eliminated, and Mr. Kelly can be denied internet access. The real issue here is whether, by denying him bail, is it appropriate to put him in a position where he cannot assist his counsel to appear for his upcoming September 2020 trial. Now, if you guys have been following the Michael Avenatti shenanigans, y'all know that they had to pull his coattail about 3 weeks ago or a month ago, where they found out that he had been on the internet. And so they had to tell him, if you go on the internet again, we're going to put your butt back in jail. So these people have means of monitoring these people and monitoring their activity. And so if a court in New York, because I think he was found guilty in the Southern District of New York, can monitor his internet activity all the way out in California, then surely the Eastern District of New York and the Northern District of Illinois can monitor R. Kelly's internet access or even phone usage. And even with the coronavirus, and this is how you know that they're petty and full of crap. And many of y'all might not know this, okay? But you know how they keep reporting in the news about these parties that are going on and people aren't wearing masks and all of this stuff. So here's what the government is doing that they're not going to tell y'all that they're doing. The government basically can pull data from cellular towers showing large gatherings. They can pull people phone numbers, find out who they are. And this is called contact tracing. And when they talk about contact tracing in the news, they're basically saying that they've hired these people. And when somebody tests positive for coronavirus, that they can then reach out to these people and do like a questionnaire to find out where all they've been and who they've been in contact with, so they can follow up with those people, to make sure that those people get tested. Okay, that's old as dirt. They do that with HIV. Like when somebody tests positive for HIV, they have to disclose their sexual partners and all this stuff. And then the health department sends a letter to these people saying somebody you had sex with tested positive. So that's what they're telling you in the news. But what's really, really happening behind the scenes is they're pulling cell phone data, smartphone data, and they're determining like who all was at this house party in Chicago, who was on this big gathering at the beach, in Pensacola. They can pull that information using your smartphone data. And then what they do is they match that information with people who are testing positive for coronavirus. And then they're basically tracing your movement in all the places that you've been to narrow down like where you contracted it, how many people you have spread the disease to, and then they can go in and contact, like if you went to, say you was at this party and then you tested positive 2 weeks later. So now they can go back using your phone information and find out all the places, following your breadcrumbs, all the places that you've been, if you've been to work, to the grocery store, etc. And then they can start monitoring people who were at those places at the same time you were at those places. to determine how many people you infected with that disease. So if they can do all of that, trust me, they can monitor R. Kelly's whereabouts and what he's doing. So this next section is called Facts. So the facts are set forth more fully in the accompanying declaration of Thomas A. Farinella. It says, in brief, Mr. Kelly is a 53-year-old with no prior criminal convictions who is charged with offenses in Illinois State Court and in the federal courts for the Northern District of Illinois and the Eastern District of New York. Mr. Kelly was granted release on bond in the Illinois State Court case. He has no bond without issue. He was on bond without issue until he was indicted and detained in each of the federal cases, despite the fact that federal pretrial services in the Northern District of Illinois, who would be responsible for his supervision, recommending that he be released, and thus that a combination of conditions exists that would secure his appearance and alleviate any perceived danger to the community. Mr. Kelly should have been released from the start in these matters, and the initial decisions to detain him were themselves erroneous. But now with the COVID-19 pandemic, there has been a cataclysmic change in circumstances that calls for his release. The simple fact is that a jail setting is not somewhere that is safe for COVID-19. The conditions at the MCC Chicago have deteriorated to the point they are arguably inhumane, even for the healthiest persons. Contrary to the district court's finding that Mr. Kelly's medical condition is insignificant and treatable, Mr. Kelly has been required for months now to be in a permanent lockdown setting in a cell because of the COVID-19 crisis. He has minimal opportunity for movement, no opportunity for recreation, and no opportunity for social interaction with anyone other than a cellmate. Mr. Kelly's current cellmate is a foreign national who is difficult to communicate with. Commissary is sporadic, once a month, and phone calls are infrequent. When inmates are moved, they are still crowded onto an elevator. Clearly, these social distancing measures do not make inmates the priority, and the results show it. With the staff having first-person knowledge of the health risks inside the institution, even bathrooms and showers present a haven for infestation. There is no visitation, social or otherwise, including legal visits. His trial in the Eastern District of New York is set for September, and trial in the Northern District of Illinois for late October. Mr. Kelly is unable to efficiently and meaningfully consult with his counsel to adequately prepare for this upcoming federal criminal trials, for which he faces up to de facto life in prison. Further, if Mr. Kelly remains in custody, his counsel will be forced to risk their own health by way of visits to the MCC Chicago. But to be clear, such visits are not currently even allowed and have not been for months. Counsel should not be forced to visit with Mr. Kelly in jail during this pandemic. Counsel should not have to endanger their own health in order to fulfill their duties to their clients. In any event, as noted above, in-person visits with attorneys are not even allowed. Phone calls with counsel are also extraordinarily limited and require that they be scheduled well in advance. Any such phone call poses concerns as to confidentiality, particularly where one of the callers is within a correctional institution. More importantly, communicating over the phone does not allow counsel the opportunity to show or explain documents to Mr. Kelly or vice versa. When and if visits are eventually allowed, whenever that might be, Mr. Kelly's counsel will be competing with all the other attorneys who need to speak with their clients. These visits will also likely be limited in time, as well as in what materials are allowed to be brought inside. Mr. Kelly is not a priority for the MCC Chicago because each of the inmates have the same rights to access counsel. With respect to the types of conversations that need to be held to prepare for criminal trials of this magnitude, there is simply no meaningful substitute for old-fashioned face-to-face conversations. Argument. A. Burden of proof and standard of review. Under the Bail Reform Act, a court is required to order the pretrial release of a defendant on personal recognizance or after the execution of an appearance bond, unless the judicial officer determines that such release will not reasonably assure the appearance of the person as required or will endanger the safety of any other person in the community. And I already read, all of these are under Section Code 18. And so this is 3142B. And then he says, release is mandated unless, quote, there is no condition or combination of condition of release that will assure that he will not pose a danger to the safety of any other person of the community. 3148B2A, where, quote, there is probable cause to believe that while on release, the person committed a federal, state, or local felony, a rebuttal presumption arises that no condition or combination of conditions will assure that the person will not pose a danger. 3148B2, while not dispositive, it should be noted that the underlying conduct of which Mr. Kelly is charged occurred nearly 2 decades ago. The Act mandates a simple 2-step inquiry, and a defendant may be detained pending trial only if both prongs are satisfied. And so Section Code 18, 3142E, and 3142F. First, the government must demonstrate the defendant has been charged with one of the crimes enumerated in Section 3142F1. At that he must, FI, or is that a 1? F1 or FI, or that he presents a serious risk of flight or danger to the community. 3142F, see also United States versus Freedman. Thus, no matter how dangerous an individual may be, he cannot be detained unless one of these initial satisfied. See Freedman, 2D at 49. There was simply no record evidence to support a finding that Mr. Kelly is a member of the, quote, small group of particularly dangerous defendants for whom no adequate conditions can be fashioned. Mr. Kelly's continued detention is not justified based upon the record evidence, and it marks a substantial departure from the class of cases in which pretrial detention has been deemed necessary. To gather a sense of the type of, quote, particularly dangerous, end quote, individuals whom Congress had in mind under the Act, one need look no further than the line of Second Circuit cases addressing pretrial detention. So since we at the Second Circuit, let's go ahead and talk about what you guys have decided. It says, these cases confirm that Mr. Kelly is clearly not the type of person for whom pretrial detention was intended or is warranted. Mr. Kelly is 53 years old, does not have any criminal history, and is presumed innocent. This case has been handled as a presumption case. In a presumption case, a defendant bears a limited burden of production, not a burden of persuasion. And so I'm going to read the cases that they cite to support what they're saying. So United States versus Sission, or Sissacone, denying bail for alleged organized crime boss charged with supervising multiple acts of extortion, loan sharking, money laundering, and witness tampering. United States versus Ferrante, I'm sorry guys, it's late. reversing district court's order releasing defendant charged with arson resulting in death and witness tampering. Defendant also allegedly shot a criminal associate and directed others to intimidate tenants at a building he owned and to terrorize and kill a tenants' rights activist who was later found murdered. United States versus Millen. Reversing district court's order releasing defendant who had ordered numerous shootings, beatings, and a contrite murder and had issued threats against the families of witnesses who testified adversely to him at trial. United States versus Arena, overturning district court order releasing alleged acting boss and captain of the Colombo crime family who were charged with murder, conspiracy to murder, and illegal possession of weapons. Evidence showed that plans existed for further murders. And illegal possession of weapons. Evidence showed that plans existed for further murders. United States versus Rodriguez, vacating district court's order releasing defendant who was introduced to an undercover agent as a hitman, agreed to perform a murder in exchange for 1 kilogram. Wait, hold on. I messed up my screen here. Okay. Let me get back. Oh, I'm sorry. Legal possession shows. Okay, introduced to an undercover agent as a hitman, agreed to perform a murder in exchange for 1 kilogram of cocaine and allegedly shot someone in the kneecap over a $60 debt. United States versus Shakur, reversing district court order releasing a defendant charged with 19 separate predicate acts of racketeering, including 3 murders, 2 of which were murders of law enforcement officers, 3 armed robberies or armored trucks, 1 bank robbery, 7 attempted robberies, and 2 armed kidnappings. United States versus Colombo, overturning district court order releasing defendant who operated his own crew within the Colombo crime family and directed crew members to rob large-scale drug dealers and distribute narcotics, to abduct a drug dealer, assault the manager of a car dealership, to extort a restaurant owner, to attempt to murder a government informant, and to rob passengers on a flight to Atlantic City. United States versus Gotti, affirming order of detention for alleged leader of Gambino crime family who was charged with 3 murders, conspiracies, and attempted murders, as well as extortion and other crime. So, if I'm understanding this correctly, they're saying that all those cases I just read to y'all, with the exception of the Gambino guy, that the district court had granted these people bail, and then the circuit court had to come in and say, hold up, no, them people can't be out on the street, they need to be held. So this is what they're comparing R. Kelly to, saying that he's as dangerous as these people that have committed all these murders and robberies and all this stuff, hijacked planes and everything. That's what they're trying to say. He is that level of a dangerous offender. So it says, let me see. Okay, then it picks up, before I started reading all that, it says to rebut the presumption, the screen, I'm sorry guys. To rebut that presumption by coming forward with evidence that he does not pose a danger to the community, United States versus Mercedes, the United States versus Rodriguez, quote, to determine whether the presumption of dangerousness is rebutted, the district court considers 1, the nature and circumstances of the crime charged, and 2, the weight, 2, the weight of the evidence against the defendant. 3, the history and characteristics of the defendant, including family ties, employment, community ties, and past conduct. 4, the nature and seriousness of the danger of the community or to an individual. Although this court reviews a trial court's findings of, quote, historical facts underlying the conclusion that the defendant is a risk to flee or poses a danger to the community, for clear error, United States versus Melendez Carrion, danger to the community is not as clear a concept as risk of flight and has not been fully developed as a basis for pretrial detention. Application of the dangerousness ground for pretrial detention may therefore implicate legal interpretations to a degree somewhat greater than the ground of risk of flight, with a corresponding broader scope of review. See also United States versus Farinati. Our scope of review is slightly broader than clear error with respect to the ultimate determination that a defendant does or does not present a risk to the citizenry. And then continuing quote, while appellate review is deferential, it is nevertheless guided by the traditional presumption favoring pretrial release for the majority of federal defendants. United States versus Burkham, summary order, quoting United States versus various, at bottom, quote, it is only a limited group of offenders who should be denied bail pending trial. United States versus Shakur, reprinted in 1984, blah, blah, blah. And then B, Mr. Kelly met his burden of establishing that he does not pose a danger to the community or a risk of flight. In determining whether the defendant has rebutted the presumption that he is dangerous and a flight risk, the trial court is obligated to consider certain factors, including the nature of the charges against the defendant, the weight of the evidence against him, his history and characteristics, and the extent to which his release would pose a risk to any person or the community. See also Mercedes. The district court considers section 3142G factors to determine whether the presumptions of dangerousness and flight are rebutted. With respect to the nature of the charges and the weight of the evidence, it is difficult for defense counsel, who has not yet even seen a single meaningful witness interview during discovery, to opine on these issues. And so opine is basically to comment, to have an opinion on the issues. But suffice it is to say that the charges themselves are not particularly egregious, do not entail acts of violence, and largely involve events from decades ago. While the charges are serious, they are not the type of charges that should implore a court to detain an individual because he is a real and present danger should he be released. Moreover, that is only one factor in the overall analysis. Here, the district court was aware of but utterly ignored Mr. Kelly's historically perfect record of compliance with court conditions. It is undisputed that Mr. Kelly was granted release on bond in an Illinois state court case involving similar allegations in 2002. The charges he has been facing, I don't know why the screen keeps going now. The charges he has been facing could have landed him in prison for a decade or longer. In other words, those charges were equally serious to the ones now at issue. Nonetheless, Mr. Kelly appeared at each and every court appearance in that action over a period of almost a decade. He never once missed a court appearance and never had any issues with respect to the conditions of his release. He was even allowed to repeatedly travel overseas while on bond in that matter and return each time without incident, even though he was not subject to any form of monitoring. Now, why Steve Greenberg didn't put all that in his motions that he was filing, I don't know. Moreover, again in early 2019, after posting significant monetary bail in a still pending state court case in Cook County, Illinois, Mr. Kelly appeared at each and every required court appearance. He also met all other conditions of his release. in fact, with federal agents approached him to arrest him in connection with the present case on a public street, he was fully cooperative. Indeed, and let me stop there. Does anybody find it like really strange that we still have not found any video of R. Kelly being arrested on a public street? Like, don't you think that there are cameras at all these businesses that TMZ would have paid these businesses, paid somebody, put out if you was driving down the street and saw R. Kelly get arrested and recorded the incident, or if you didn't even know it was R. Kelly, but you recorded an incident of somebody being arrested on Michigan Avenue or wherever street he was on, I just find it hard to believe that none of that video has surfaced. And speaking of video, our boy Shabazz, who did the Precedents docu-series on R. Kelly. So he's on Instagram. It has just like a more professional, he's covering the protests and everything that's taking place. But like his approach to covering the current climate is totally different than his approach to how he did that Precedents docu-series. But anyway, he posted a video, and I want you guys to go look at it on IG. I think his handle is as is Entertainment Network or something like that. But anyway, he posted a video, you guys, of one of R. Kelly's court dates. And remember how all the media used to be gathered in the lobby, to record him going in to court with the Illinois case. So why at the end of one of those press conferences, all the reporters and photographers got together for a group picture and waved, talking about goodbye, R. Kelly, like just rude and disrespectful. I want you guys to go find that on IG. As is Entertainment Network, I think is the name of his handle. And come back and let me know what you guys think about that situation. And I actually might post something in my community tab, but I wanted to share that before I forgot about it. So he goes on to say, indeed, Mr. Kelly knew for a significant period of time that he would be charged federally, but never attempted to take any steps to abscond. And this is my words, unlike Russell Simmons, who got the hell out of the United States, okay? So, him and R. Kelly could have been over in Bali together, okay? But he stayed. He said he wanted to face this head on. So with respect to the issue of flight, certainly in the current environment, it would be difficult, if not impossible, for someone like Mr. Kelly to walk through an airport and blend in with others, not to mention the fact that he could never possibly pass through a TSA checkpoint in the first instance, even if airport personnel somehow did not recognize Mr. Kelly. He has no passport. And to add to that, you can't even fly out of the country right now, and countries are barring U.S. citizens from coming into their country. And I think I told you guys before, I technically should be in Egypt right now. I was going on a trip to Thailand, Egypt, and Dubai. And so I think we were going to leave Egypt maybe today or tomorrow and go back to Dubai. The trip was going to start in Dubai, go to Thailand, go to Egypt, and then back to Dubai. And then I would be returning to the United States this weekend. But that trip was canceled, okay? And we can't even figure out when we can reschedule that trip because none of these countries are allowing U.S. citizens to fly into their country. So where are Kelly going? Where he going? Okay? Let us know. So then it goes on to say, additionally, Mr. Kelly has no means to flee. The fact is that Mr. Kelly possesses almost no liquid financial resources. The government was unable to point to any evidence whatsoever that suggested that Mr. Kelly possesses a desire to flee, in this case or otherwise. Even if such a desire actually existed, Mr. Kelly has nowhere to go, no way to get there, and no money to survive off of. Significantly, the district court impermissibly overlooked or ignored the proposed combination of conditions put forth by Mr. Kelly and his counsel, including monitored home confinement, a prohibition on the use of electronics by Mr. Kelly, and a prohibition of Mr. Kelly having contact with anyone other than his attorneys and his live-in significant other. With these conditions in place, Mr. Kelly would not pose any risk of flight or danger to the community. In some, before court appearances, he would be confined to his residence. Moreover, with no ability, you guys, I'm sorry, this thing keeps jumping around. Moreover, with no ability to use or access electronic devices, Mr. Kelly would have no access to the outside world and no means of engaging in any form of obstruction. He would effectively be subject to all conditions he is now, sans the risk of death. Mr. Kelly is an individual who is scared for his life because of COVID-19 and the lockdown conditions at the MCC Chicago, with absolutely no intention of violating the orders or release of any court. Not a shred of record evidence existed to the contrary. Surely the above referenced record evidence should have been more than adequate to shift Mr. Kelly's required burden of production to the burden of persuasion required to be made by the government. And then C, the government did not meet its burden of persuasion by clear and convincing evidence that Mr. Kelly posed an irremediable danger to the community. Even in a presumption case, the government retains the ultimate burden of persuasion that the defendant presents a danger to the community. Mercedes, in its decision denying Mr. Kelly release, the district court held that the government sustained its burden of proving by clear and convincing evidence that the defendant poses a danger to the community. Rather than relying on any record evidence put forth by the government, the district court looked to the charges on their face value is what they're saying, failing to engage in a critical analysis as to the facts underlying these allegations. Significantly, the government did not even try to shoulder this burden. It asserted, without putting forth any actual record evidence, that the mere allegations of the indictment established that Mr. Kelly posed a danger to obstruct justice. The government did not argue, let alone substantiate with record evidence, that no condition or combination of conditions of release will assure that Kelly will not pose a danger to the safety of any other person or the community. While the district court was allowed to look to a probable cause determination with respect to an obstruction charge as evidence, it must look to the underlying substance of that charge in order to ascertain a potential present danger. Here, in a footnote, the district court looked to the statutory language charge, which lists all of the different types of behavior that could potentially constitute obstruction. The district court clearly did so in order to combat Mr. Kelly's argument that the witnesses could not be tampered with, regardless of the absence of any record evidence suggesting that Mr. Kelly had any intent to tamper with them or otherwise obstruct justice. See District Court's May 15, 2020 order at FN4 docket number 68. This was improper. The government should have been required to put forth actual evidence, or in the least a substantive proffer, that Mr. Kelly posed a danger of obstruction at present. The district court had no basis for simply denying the charge of obstruction sufficient to amount to a danger of obstruction in the present carte blanche, particularly where it relates to conduct that is alleged to have occurred more than 15 years ago. And so they're basically saying that they're making these statements as though they are factual and they have proof that he obstructed justice, but they're not putting that information on the record and using it to support their case. They're just saying, well, he was charged with obstruction of justice in the Northern District of Illinois case, so therefore it must be true, but not actually saying what the evidence is to support that. Even where there is a rebuttal on presumption in favor of detention, the query becomes whether there are any conditions or combination of conditions that would mitigate against the risk. Detention is only appropriate if the court finds that no condition or combination of conditions would reasonably assure the appearance of the person as required and the safety of any other person in the community. In determining whether any condition or combination of conditions is sufficient, the court can consider several factors, including the nature of circumstances of the charged offense, the weight of the evidence, the history and characteristics of the defendant, and the nature and seriousness of the danger posed by the defendant's release. With a district, court does not consider the factors set forth in 3142G in reaching its ultimate finding on the existence or non-existence of conditions. The finding will be subject to more flexible review. Shakur and Citing Barris. In the present case, however, the district court placed far too much weight on these factors. While the government typically relies on 18 U.S.C. 3142G2, the weight of the evidence factor, this factor should be the least important consideration. United States versus Gibro. This is because of the presumption of innocence and the lack of discovery at the bail detention phase of the process. Moreover, the Bail Reform Act specifically states that nothing in this section shall be construed as modifying or limiting the presumption of innocence. The record contained no evidence suggesting that Mr. Kelly would engage in obstruction at this time, thus taking the teeth out of the argument that he is dangerous. The community danger feared here is witness tampering. Yet there was no record evidence that Mr. Kelly would be able to contact any of the witnesses in this case if he were released, and since barring contact with all others would be a condition of release, there was no danger shown. The indictment contains reference to 6 Jane Does. The defense has previously requested and moved that each of them be identified. The district court denied that request with respect to Jane Does 2 and 3. Therefore, to date, their identities remain unknown to the defense. Docket 38. The government has identified a picture of Jane Doe number 4 and provided no further information about her. And Jane Doe number 4, did we say that was Geronda Pace crazy butt? I think so. To date, predicated solely upon that picture, the defense has been unable to identify that individual. This means that defense counsel and Mr. Kelly do not even know the identity of 3 of the 6 Jane Does. The simple fact is that Mr. Kelly poses no genuine danger to the community, let alone one so pronounced that it cannot be remedied by appropriate conditions of release. Indeed, defendants... no genuine conditions of release. Indeed, defendants accused of posing greater dangers than Mr. Kelly have been released pending trial. See United States versus Sabani. And this is driving me crazy. This thing keeps jumping around. Let's see. Okay, United States versus Sabani. Reversing order of pretrial detention for defendants charged with holding, quote, 2 Indonesian women in peonage at their Long Island home, denying them freedom of movement, subjecting them to serious physical abuse, and paying them no wages, end quote, given availability of bail conditions that would reasonably assure defendants' appearance at trial, United States versus Chimaringa, upholding pretrial release of defendant charged with conspiracy to commit armed robbery because bail conditions would reasonably assure community safety and defendant's appearance, United States versus Blovelt, granting bail to defendant accused of, quote, very serious, end quote, charges of sexually exploiting a minor to produce child pornography. Granting bail to defendant accused of very serious charges of sexually exploiting a minor to produce child pornography. United States versus Soto Rivera. Granting bail to defendant charged with bank robbery and with killing the assistant bank manager. This court, quote, may weigh the evidence if the district court considers those factors, but nevertheless, in reaching its ultimate finding, relies primarily on some factor or factors not set forth by Congress. Shakur, not only did the district court not address the statutory factors, it in fact relied on a factor not set forth by Congress with regard to the federal pretrial services purported inability to monitor Mr. Kelly. The district court found, quote, given the pandemic, where the judicial system's oversight capabilities are curtailed, Judge Donnelly's decision dated April 21st, 2020, emphasis added there was no basis for that finding. No one ever presented the district with any evidence of any kind to support that finding. D, the government did not meet its burden by a preponderance of the evidence that Mr. Kelly poses a risk of flight. There is zero evidence from which the court can infer that Mr. Kelly is a risk of flight, let alone the required serious risk. To the contrary, Mr. Kelly's history directly undermines the government's unsupported assertion of flight risk. Perhaps more significant is Mr. Kelly's record of appearance, and then they go back and repeat, how he showed up and everything. It says he was ultimately acquitted by a jury on all charges after weeks of trial. Mr. Kelly appeared dozens of times in that matter. He was never even late. Additionally, he was allowed to travel, always returning. As the defense explained in the initial bail hearing, the subsequent hearing before the district court, and in 3 motions requesting bond, the presumed risk of flight proffered by the government is entirely groundless. The district court's conclusion that Mr. Kelly will flee was reached without any record evidence, was premised entirely upon speculation, and defies logic. Here it is undisputed that the fact that Mr. Kelly was being investigated by the federal government was well known. Certainly, it is undisputed that he knew. The record before the district court established that in the face of the fact, Mr. Kelly still went about his normal activities. There was never any concern that Mr. Kelly was going to flee, notwithstanding the swirl of rumors of investigation and looming indictment. When the federal agents arrested Mr. Kelly, he was walking his dog. He was fully cooperative, never attempted to flee, and never made any plans to flee, nor did the government even attempt to argue that Mr. Kelly had done anything that suggested preparations for flight. Equally, or perhaps even more importantly, when Mr. Kelly was indicted for very serious charges in Cook County, Illinois in the spring of 2019, he voluntarily surrendered the same day. When charges were added to that action and he was told that he had to appear in court for an arraignment on those additional charges, he promptly and voluntarily did so. Notably, the Illinois prosecutors did not even ask to increase or change any condition of the bond at that time. Additionally, it was misreported in the magistrate judge in the present case that Mr. Kelly travels internationally. He does not. It is undisputed that his last international travel occurred approximately 8 years ago. In any event, because Mr. Kelly's passport has already been surrendered, he cannot travel internationally. Let's see. None of the typical indicia of travel risk exists in this case. Discussing the types of factors that might support a finding of flight risk, the Second Circuit in Friedman pointed to United States versus Coonan, where the defendant had been a fugitive for close to 4 months on the very charges for which he was incarcerated, and his fugitive status ended only by his capture, and United States versus Jackson, where the defendant has shown skill in avoiding surveillance, had lived from hotel to hotel, had hidden assets, and had used a number of aliases. Neither of those cases bears even a remote resemblance to the facts presented in this case. Finally, there are various levels of monitoring or even home detention that would ameliorate any conceivable risk allegedly posed by Mr. Kelly. Moreover, speculation about United States versus Lee, relaxing conditions of pretrial release because, quote, speculation about the possibility that Lee might disclose information during treatment that suggests he poses a threat is no substitute for evidence that he poses one now. United States versus Bodmer, granting pretrial release where, quote, the government's argument is mere speculation because it provides no evidence that Bodmer has any bank accounts outside of Switzerland, end quote, that he could use to finance flight, emphasis in original. In addition to substituting speculation for evidence, the district court failed to address, quote, whether the presumption of dangerousness is rebutted given, 1, the nature and circumstances of the crime charged, 2, the weight of the evidence against the defendant, 3, the history and characteristics of the defendant, including family ties, employment, community ties, past conduct, and 4, the nature and seriousness of the danger to the community to an individual. Mercedes, which is a case, in the district court's recent decision dated May 15, 2020, the court found that both indictments charged the defendant with serious crimes that span years. In the district, the indictment charges that for almost 24 years, the defendant led an enterprise, the purposes of which were to promote the defendant's music, to recruit women and girls to engage in illegal activity with the defendant, and to produce pornography. In the Northern District of Illinois, the defendant is charged with participating in a long-running conspiracy to obstruct justice and a conspiracy to receive pornography. The indictment essentially alleges that Mr. Kelly's music career constituted a racketeering enterprise designed to obtain sexual partners. This ignores the fact that he made successful music, won several Grammy Awards. It suggests that things such as the issuance of backstage passes, and engaging in meet and greets with fans constitute criminal activities. It is a perversion of the purpose of the racketeering statute and surely extends the quote, or in any sexual activity for which any person can be charged with a criminal offense, language far beyond its intended use. See also Jabardi versus United States, quote, transportation of a woman or girl, whether with or without her consent, or causing or aiding it or furthering it in any of the specified ways are the acts punished when done with a purpose which is immoral within the meaning of the law. E, the continued and unnecessary incarceration of Mr. Kelly also runs afoul of the 8th Amendment. And I know a bunch of people were saying, we keep hearing Sharon and other people say that his constitutional amendments are being violated. What amendments are being violated? So we finally get one put into this, and they're saying that it is the 8th Amendment. It says continued incarceration that is not absolutely essential may also violate Mr. Kelly's rights under the 8th Amendment to the United States Constitution. The Supreme Court has held that prison officials may not ignore a condition of confinement that is sure or very likely to cause serious illness and needless suffering the next week or month or year. Helling versus McKinney. Detention in such circumstances may well violate the 8th Amendment by exposing a prisoner to an, quote, an unreasonable risk of serious damage to his future health, end quote. Thus, pretrial detainees' due process rights are at least as great as the 8th Amendment protections available to convicted prisoners. So, Maddox versus City of Los Angeles. See also Oregon Advocacy Center versus Mink. We have recognized that even though the pretrial detainees' rights arise under the Due Process Clause, the guarantees of the 8th Amendment provide a minimum standard of care for determining their rights. Conditions as they presently exist within the MCC Chicago are of the kind that were contemplated by the Constitution, and a remedy exists for the court or to craft. The Supreme Court has held that the 8th Amendment prescribes more than physically barbarous punishments. See Gregg versus Georgia, Trop versus Dulles, Williams versus United States. The 8th Amendment embodies, quote, broad and idealistic concepts of dignity, civilized standards, humanity, and decency. End quote. Jackson versus Bishop, against which we must evaluate penal measures. Thus, we have held repugnant to the 8th Amendment punishments which are incompatible with, quote, the evolving standards of decency that mark the progress of a maturing society, end quote. And then they cite all those cases over again. So here it is clear that leaving this defendant at the MCC Chicago is rapidly becoming a death sentence, and as such it is against the evolving standards of decency that mark the progress of a maturing society. The same analysis is relevant in the pretrial context where each day Mr. Kelly's health is at risk. An 8th Amendment violation arises where an incarcerated person establishes, quote, the seriousness of the potential harm and the likelihood that such injury to health will actually be caused, end quote, by the medical threat, here an escalating national pandemic. Person versus Sheehan, citing Helling. In assessing such a constitutional claim, this court must also determine whether the alleged risk is, quote, not one that today's society chooses to tolerate, end quote. Given the speed with which the coronavirus is spreading and the exacerbated dangers in jails and prisons, reduction of the population is critical to help prevent a mass outbreak. To be sure, there may be some people who present such a grave danger to society that they cannot be released pre-trial. Mr. Kelly is not such a person. Any alleged violation of law, a defendant is on, Lord Jesus, I'm sorry guys. A defendant is on pre-trial release will necessarily breach the trust of the court that released him. However, the relevant standard for denying bail is not breach of trust, but whether the person poses so much of a danger that absolutely no condition or combination of conditions of release will reasonably assure community safety. And that's Section 18, Code 18, 3148B2A. The district court decided without any record evidence to support its decision that Mr. Kelly poses such a danger, is likely to flee, and that federal pretrial services cannot possibly monitor him to the extent any danger is suggested by the record evidence. It is that Mr. Kelly will allegedly tamper with witnesses and flee if released. Those dangers are completely removed by requiring home confinement, limiting Mr. Kelly's ability to use a phone, the internet, and all other electronic devices, limiting Mr. Kelly to contact only with his lawyer and his live-in significant others. F. Mr. Kelly has a fundamental right to proceed to trial expeditiously and a fundamental right to prepare for that trial. Indeed, an important part has seemed to have gotten lost in all of this, and that is that Mr. Kelly has a fundamental right to proceed to trial expeditiously whenever practicable. This issue of whether that trial can take place in September, as presently scheduled, given the pandemic, is a different issue than whether, if the trial cannot proceed, he can still be prepared for trial. It is understandable that the trial may not move forward in light of the pandemic, but it is unfair if the trial cannot move forward because he was held in custody during the pandemic and therefore he and his counsel could not prepare for a trial. Presently, none of Mr. Kelly's attorneys are even allowed visit, and so they repeat that, and then they talk about the 15 minutes, how they can't show him any documents, which he kind of stated in the brief submission at the beginning. The risk, failure to release Mr. Kelly would inevitably lead to a reduction in his constitutionally mandated right to access counsel and to assist in his defense during what the Supreme Court has found to be the most critical period of a case proceeding, the time between arraignment and the beginning of a trial, Powell versus State of Alabama. Recognizing the importance of this period of time, Bail Reform Act included a provision that would allow a judicial officer to permit the temporary release of a detainee if the judicial officer determines the release, quote, to be necessary for preparation of the person's defense or for another compelling reason. Several federal courts have discussed the burden incarceration has on a defendant's ability to assist in their defense. The court in U.S. versus Vida reasoned that a defendant released on bail is available 24 hours a day to assist in their trial preparation, track down evidentiary leads, and provide key factual details in drafting motions and negotiations. U.S. versus Vida. See also Barker versus Wingo. Additionally, the defendant may be the only person that is able to identify, explain, and help attorneys to understand the evidence and his defense. The court in U.S. versus Vida went on to note that the quality of the detainee's legal defense is likely to diminish dramatically the longer he or she is incarcerated. Moreover, attorney-client communication is an essential component of the meaningful access to courts guaranteed under the Constitution. See Dreyer versus Siliff, internal citations omitted, and Gleason versus Sangamon City Sheriff's Department. Hospitalized pretrial detainee with AIDS stated claim for violation of his constitutional right of access to the courts because of hospital detention policies that prevented him from attending court, filing motions, including to reduce his bond and meeting with counsel. Court found that, quote, the opportunity to communicate privately with an attorney is an important part of that meaningful access, end quote, to courts under the 14th Amendment. If a lawyer is unable to go to the jail because of the virus, is under mandatory quarantine because she or someone she is close to is exhibiting symptoms associated with the virus or has been exposed to someone who has tested positive, he can only communicate with his client by phone. In sum, Mr. Kelly is being denied his Sixth Amendment right to access to counsel. So that's 8, 14, and 6. There is no iron curtain drawn between the Constitution and the prisons of this country. Wolf versus McDonald. A court should not, quote, unjustifiably obstruct the availability of professional representation or other aspects of the right of access to the courts. Therefore, restrictions imposed by the district court should not dwarf Mr. Kelly's Sixth Amendment right to have access to his counsel and to be able to prepare for his case. Conclusion. The court should reverse the order of pretrial detention entered by the district court and remand this matter for the imposition of appropriate conditions of release. Whew, child. I thought that one gonna never end. Okay. And so that's the Thomas Farinella. That was his argument to the district court, Court of Appeals. And so like I said, this document is 208 pages long, and I just read to you guys the first 29. So we're not going to start reading the rest of this, but I wanted to point out a few things before we leave. I was reading through these transcripts, and the transcripts like give everything that was said in court. And in the, what was this one here? I'm trying to remember what was in this one that I wanted to point out. One, it shows, like, you can see the differences in the attorneys, because like when Greenberg is speaking, like he is not articulate at all. The judge is like talking over him, like, dude, get to the point. What are you talking about? But one important thing, I can't remember which one of the hearings it was. It had to be the Eastern District of, the Northern District of Illinois, where the prosecutor stated that they have a signed document, signed statement from Rashonda. I mean, they don't call her by name, but by the witness, basically talking about Rashonda, stating that, yes, she is the person in that video. That was the first thing. Oh God, what was the other? They talk about the fight, how they haven't gotten a lot of the discovery. In one of the court hearings, they talk about the Northern District of Illinois is saying they have like 4 videos, but the first video is the video from the original trial. Then there's supposed to be 2 more videos that I guess Greenberg has received. But then there's a 4th video that they are saying has not been turned over, and they don't know if it exists. They talk about the storage unit and what all was in the storage unit, and how as of whatever hearing it was, they still haven't received any information or any discovery pertaining to what the government pulled out of those units. And if I was reading this correctly, it seems that the Northern District of Illinois went into the storage unit first. Then New York went into the storage unit, or New York was saying that they hadn't been in the storage unit yet. But still, nobody knows what they took out of this storage unit, no discovery. And they may have that information now, but in these transcripts that is included in this document, at the time of these court hearings, that discovery of what was taken out of that unit had not been turned over to to the counsel for R. Kelly. Oh my God, there was one other thing that I thought was interesting that you guys might have wanted to know. Oh, and then they talk about, I don't know if you guys have ever seen that letter, but it was supposed to have been a letter that R. Kelly allegedly sent to Faith, basically threatening her. And I know I've talked about this letter before in one of my previous videos, where he was basically threatening her that if she moved forward with her civil suit, that, you know, he was going to expose her. And so they go on to talk about how the Susan Logan's lady would contact this other law firm and basically tell them how she had handled all these cases involving women that wanted to sue R. Kelly, and that, you know, basically, here is the document, just take it to him, he'll sign it, you know. And so they were saying how he didn't know what he was signing, and the judge in that hearing was like, what do you mean he didn't know what he was signing? And it was like, basically, he had these people working for him, these lawyers and accountants and whatever working for him, and he trusted these people so that when they came to him and said, we need you to sign this check, or we need you to sign, you know, this contract or whatever, he was trusting that they had read the contract or they knew what the check was for, because that's what he was paying them to know. And so they would just tell him whatever, oh, you need to sign this, or you need to give this person this check. And then he would just sign off on it. So he had no clue what he was signing. And then they talk about the check that he gave to Rashonda for like $1,500 right before he was arrested, or in 2015, or I can't remember the date, but anyway, I know the check was to Rashonda, and said that it had written in the subject line settlement. And they was like, well, first of all, we don't even know if he wrote settlement in the memo line, and if he did, it doesn't state what the settlement was. And like, why didn't he, in any other checks that he gave to this person, he didn't write settlement in the subject line? So how are you now saying that? And then they talk about, you know, Azriel and the fact that she was still allowed to stay with him. And I think those were the interesting things that I wanted to point out. Like I say, just, you know, 200 pages of stuff. And I might go through this again to, and then they have like the indictments, the superseding indictments. All of those are in here, and I already did videos reading all of those. I think those were the important things. Though the most important was them saying that they have this sworn statement from Rashonda saying that, yes, it was her in the video. However, my understanding is that the defense hasn't seen that statement. This was just something that the prosecutor has said, but I'm thinking that the prosecutor said it, when they have to back it up in the end. And so, yeah, just really interesting. But those were the things that I can remember. Tomorrow I'll go through this again to see if anything else, you know, reading those transcripts to see if there's anything that I forgot to mention here or that I think you guys would be interested in, and I will bring it back to you. And then one thing I want to say before I leave, you know, when the term comes to remaining positive and upbeat and believing that he's going to come through this. And that is, you guys who've been following me for a while, you know, the whole situation. I've talked to you guys before about my kid's dad and, you know, him being incarcerated under the drug kingpin law. Well, I recently found out that, so the drug business that he was accused of running, he actually allegedly took that business over from another family that had gone to prison. And so the father, he actually died. He was released under Obama's compassionate care, or I can't think of what the exact word is, but basically, if you're serving a life sentence and you become ill in prison or you get really old, they will let you come home to die at home instead of dying in prison. And so the father was released under that, and he did eventually die, but the son was sentenced to life in prison. Well, 3 months ago, the son's life in prison, meaning no eligibility for parole, you're going to die in prison. He actually argued his own case. Like, he went to the law library, sort of like 50 Cent's a show. What's the name of that show? And I watched it. It was really good, For Life or something like that. But anyway, he argued his own case, and he had his life sentence commuted. And he was released from prison about 3 months ago. And then there's another guy who went to prison under the drug kingpin law who also was sentenced to life in prison. And the two of them were in the same Oklahoma federal penitentiary, and they became friends. And so both of them argued their cases and had their cases overturned. And so now they're going to try and help other inmates who were sentenced, you know, with these crazy, crazy sentences. And like I told you with my ex, he got like, you know, several life sentences, plus he had 4 20-year sentences. So he has already served those 4 sentences that amounted to 80 years, but they were concurrent. So those are done with out of the books. And so now he has to argue these multiple life sentences. And so, you know, they basically are starting on this journey where they're going to try and help other inmates get out. And I don't think I mentioned this, but my ex's nephew was also sentenced to like 3 life sentences under the same case. And his sentence was actually commuted to 6 years because of a precedence case out of Jacksonville, Florida, where this 17-year-old, and his nephew was like 17 years old when all of this went down. And basically somebody argued their life sentence. And so the Supreme Court ruled that juveniles in these drug kingpin cases cannot be sentenced to life in prison. So there's like a lot of people who went to prison under the drug kingpin law that were juveniles whose sentences were overturned and they were released for time served. And so I share that with you to say that never give up hope. And the guy, Jed, and the other guy, I can't think of the guy from New York case. And I'm actually going to drop a link to a video that they did on YouTube. And so what they said is if you go into prison, like they tell you, you got life in prison or we're going to give you life in prison. If you go in there thinking I'm going to spend the rest of my life in prison, guess what? You're going to spend the rest of your life in prison. But if you go in there saying, and both of them said that they said from day one, I am not spending the rest of my life in prison. I don't know how many years it's going to take me to overturn this, but I would not die in prison. And now both of them are out. And so you just have to pray, pray that, pray for R. Kelly's strength. If he believes that he's innocent of all these charges, then pray that he can hang in there and endure and get through whatever is being thrown his way. And that if he believes he will one day walk out of that jail, whether it is on appeal of this pretrial detainment, or if he's found not guilty on all the charges, or if he's found guilty and then later appeals. And because, Bill Cosby is now getting the ability to appeal his case. So no matter the circumstance, if he continues to hold up hope and believe that he will not die in prison, that he will not spend the rest of his life in prison, then guess what? It's not going to happen, and God will make a way for it not to happen. And so for those of you who are really his fans, that are really praying for him, really rooting for him, not just trying to be entertained, but trying to be educated about this case and trying to see what you can do to help, then you've got to stay positive and you've got to stay uplifted and, just continue to have faith that even though we don't see it, even though we think Greenberg is a horrible attorney, we have to stay positive and continue to pray and continue to uplift this system, the situation, that justice be done, in this case. And so That's it for me, guys. Okay. So until the next time, guys, go ahead, leave your comments below, rate the video, subscribe to the channel if you haven't done so already, share the video, and until the next time, I shall talk to you guys later. Bye-bye.